Hello, and welcome to this episode of The Diary of a Lawyer. And today I just want to talk about the Supreme Court decision on the Indian Child Welfare Act. So, as we know, the Supreme Court left the act intact, which was a major victory for Native American rights, where the Supreme Court, the US Supreme Court, on Thursday upheld key provisions of the Indian Child Welfare Act, a law that was enacted 45 years ago to remedy decades of past government abuse. There are numerous reports, but according to the NPR, by a vote of 7-2, the court ruled that the law does not permissibly impose a federal mandate on traditionally state-regulated areas of power. The majority held, and it was Justice Amy Coney Barrett who wrote for the majority, who pointed out to 2 centuries of precedent that that established a broad congressional right to legislate on Indian affairs, including family law matters. In the majority opinion, the Justice Amy Coney Barrett stated that the Constitution does not erect a firewall around family law, she noted. And on the contrary, she went on to say, we have not hesitated to find conflicts in state family law preempted, quote unquote, by federal law. Now, the opinion, whilst it was technical, it's important to note that 2 of our 7 children are adopted as Chief Justice John Barrett's children. Then background to the specific law in question is that a law that was enacted around 1978, the Indian Child Welfare Act, known as the ICWA, was essentially enacted in 1978 after the congressional investigation found that in the 1950s or 60s and 70s, around over 1/3 of all native children had been removed from their homes, some forcibly, and placed with non-Indian families and institutions with no ties to the tribes. And to ensure that this would never happen again, the law established 3 preferences for the placement of native children when they are adopted or put in foster care. And the first preference is for placement with the child's extended family, then to other members of the tribe, and if neither of those is available, to members of another tribe. Now, those preferences were challenged by the state of Texas and by non-Indian adoptive parents. They argued that first, that the law unconstitutionally supplanted the core function states and their traditional role in family law matters. And second, that the adoption preferences were an unconstitutional racial classification. However, on Thursday, the Supreme Court explicitly left the Indian Child Welfare Law intact, which led to obviously happiness and celebrations among Indian tribes. The court's decision, however, left one important question unresolved, which is whether the statute's system of preferences for native adoptive parents amounts to an unconstitutional racial preference. Several non-Indian adoptive parents made that argument, but the court said that for procedural reasons, they had no legal standing to bring their cases to the Supreme Court. Justice Brett Kavanaugh joined Barrett's opinion, but also wrote separately to say that in his view, the preference should remain the preference issue remains a serious one. Still, several Indian law experts say today that it may well be difficult to find a suitable test case to bring to the Supreme Court because most cases are settled without any appeal. For example, according to a Michigan State University law professor who tracks these cases nationally, Professor Kate Ford, says that in the 6 years between 2015 and 2021, there are only 14 placement preference appeals in state courts. Now, given that there are hundreds, he went on to say, of child protection cases every year, that is a very small number. Uh, Another individual, Bertram Harsh, who helped write the Indian Child Welfare Act back in the 70s, is reported to add that it is rare for an adoption case to last long enough to be a live dispute when it gets to the High Court. She said that it's going to be very difficult to find a plaintiff who is willing to not proceed to finalization of an adoption and instead keep a child and their family in limbo through years of litigation with no resolution. Indeed, all three of the adoptions before the court today have been finalized, though one non-Indian couple, Chad and Jennifer Bracken, is now trying to adopt a second Indian child. Matthew McGill, the lawyer who brought the ICWA challenge on their behalf, says he will pursue the race discrimination claim in state court adoption proceedings involving the second child, a 5-year-old girl who is the sister of the child the couple have already adopted. Now, despite the win for the Indian tribes, Chief Hoskin is worried that other Indian preferences outside of adoptions, worried about those other Indian preferences outside of the adoptions, which give special preferences for Indian gaming, Indian contracting, and Indian employment at the Bureau of Indian Affairs. There is also, he went on to say, that there's always a next challenge, particularly on equal protection grounds, because there's a whole lot of statutes out there that's specific to bringing justice and fairness to Indian country. Now, there was a dissenting view where justices, perhaps unexpected and surprisingly, Clarence and Alito wrote a separate dissenting opinion, a 40-page dissent, which argued a long-held view that constitutions, Indian protection do not extend beyond matters of trade and commerce. And Alito wrote that, in his view, Congress doesn't have the power to sacrifice the best interests of vulnerable children to promote the interests of tribes in maintaining membership. Justice Neil Gorsuch, who has a reputation as the most knowledgeable justice on questions of Indian history and the most aggressive defender of Indian rights, joined the majority decision in full. Now, the mass removal of children from their family homes in the 60s, 70s, 80s was only the latest iteration of a much older policy of removing Indian children from their families, intentionally spearheaded by federal officials with the aid of their state counterparts nearly 150 years ago. He went on to say that in adopting the Child Welfare Act, concluding, Congress exercised its lawful authority to secure the right of Indian parents to raise their families as it pleased, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. And so, the Supreme Court protected the historically Indian Child Welfare Act and the celebrations of of course, but this has wider reverberations in other minorities, not just in the United States, but in Canada and other Western countries, mainly for people of Black or African descent. But that's we will watch developments, and we shall leave it on this diary of a lawyer.